Even though we might be working on what might be considered a relatively basic prosecution matter, in most instances, we will be also relying on input and advice from our colleagues in other practice groups. For example, we routinely seek input from our litigation colleagues and as well as our colleagues in the regulatory group so we can maximize the value of product we give to the client. This allows us to help our clients maximize the opportunity in their IP portfolio as well as avoid risk. We're starting to see an interesting new trend in life sciences IP. That trend really relates to companies being much more aggressive at trying to clear potentially problematic patents. One of the mechanisms companies are using to clear these problematic patents is the use of inter partes review. There's no such thing as a one-size-fits-all IP strategy. Each strategy needs to be custom-tailored to the particular company and needs to evolve over time. We frequently counsel clients about what they're doing today and what they plan to do tomorrow because their IP strategy needs to reflect this and change quickly if necessary. There are many things life science IP companies must take into account when developing their IP strategy. For example, recent changes in the law create both risk and opportunity for companies that must be considered when developing an IP strategy. I'm often asked what makes Fish & Richardson's approach to life sciences IP different. Fish & Richardson really tries to put together teams that address every need a client has. For example, we draw on our experience from litigation, from patent prosecution, and from the regulatory group to give the client what they really need.